and welcome to the Civil Service Commission of June 13, 2018. Maybe I have roll call, please.
Commissioner Minuchin?
Here.
Commissioner McCarley?
Here.
Commissioner Devine?
Here.
Chair Carrion?
Here.
For the record, Commissioner Gazarian is absent.
Thank you. What's next?
Minutes for the meeting of May 9, 2018.
Move to approve.
Second.
Any objections? Approved unanimously. What's next? There's no one for oral communication. What's next?
Recruitment and examination report.
Mr. Doyle.
Mr. Chair, members of the Commission, this item is our current recruitment and selection activity report. As you can see, continues to be very busy activity. We have 77 processes at various stages. We've actually been really under the gun to pick up the pace for the recruitment, fill a lot of positions, and I really am proud of the staff that has really stepped up, in spite of the fact that we've recently lost two veteran staff members. So we're doing really a lot of recruitment right now and cranking out a lot of lists. So if you have any questions, I'd be happy to try and answer them for you. Otherwise, this is an open file item, and take it from there.
Any questions? I think I see Matt Doyle only has been having two, and Sean Chavez having a whole lot. So I think there should be a transfer of a whole bunch of stuff to Mr. Matt Doyle. Just kidding. What's next?
He can gladly have my spot.
Yeah, really.
Eligible list established.
Mr. Doyle.
Mr. Chair, members of the Commission, similar to the previous item, this is a note and file, and this is just a report showing you the sort of the tail end of our recruitment activity. These are our eligibility lists that have been established since our last meeting. Quite a number, 18, and looks like 6 of them are, 16 promotional, 1 open, and 1 which is promotional and open. Again, a lot of activity. But again, it's a demonstration of the work that the staff has been doing as of late. So if you have questions on any of these, I'd be happy to try and answer them. Otherwise, this too is a note and file.
All right, no questions? What's next?
Class specification for approval, Human Resources Analyst Series.
Mr. Doyle.
Mr. Chair, members of the Commission, this is a class specification for approval. This is the Human Resources Analyst position or series. And this is really just updating the specifications that are already in existence. Something you want to do periodically, and this one has not been updated since 2004. As I alluded to earlier, we lost 2 veteran analysts in the last few months, and as we plan to go out and fill these positions, we do want to tighten up the minimum qualifications, really, for the most part, with a greater focus on acquiring public sector experience. Our past experience has been that we open these recruitments, and they're very broad as far as the minimum qualifications, and we typically have lots of applications, sometimes in the hundreds. People with experience working at hospitals, software companies, the entertainment industry, temp agencies, and really, frankly, it's not realistic for people who really don't have some public sector experience to be able to compete and really succeed, at least at the journey level in this series. There are different sets of laws. There's far more restrictions. It's more heavily unionized and different overtime rules, and thus we wanted to update this and focus more on public sector experience. So upon approval, we're going to proceed with trying to fill some positions. We are going to do a recruitment at the Human Resources Analyst 2 level. We're also going to promote some individuals to the Human Resources Associate position. So there's going to be some good movement both internally and externally. So if you have questions on this, I'd be happy to try and answer them. This is an item that requires council approval or commission approval.
Mr. Examiner, I note that the both positions identified in this communication are exempt or not within the collective bargaining agreement with the Glendale City Employees Association?
Mr. Chair, Commissioner McCarley, that is true. Just to clarify, the positions from Human Resources Analyst up are middle management. and the human resources assistant and the associate are non-management, but they are what's considered employee relations confidential, which means that the individuals in these positions may be exposed. Yeah, they may be conflicted, and they may be exposed to discussions relating to labor relations as we do negotiations, preparatory work, salary surveys, things of that nature. And therefore, as you stated, it would be a conflict for them to be part of that employee group.
Thank you.
Anyone else?
Move to approve?
Hold on, just one quick question. Knowledge and skills in, it says good customer service practices. Could you do that as exceptional customer service practices? I know I'm being very picky, but then I remember the former manager said we're taking all the goods out and put exceptional. So if you can just change that from good customer service practice and put exceptional, then this will mimic what we've approved so far.
Mr. Chair, we will do that, and the exceptional is the code word these days when we're referring to customer service, so we'll make that change.
Okay, there's a motion by Mr. Manukian. Any second?
Second.
One second. Roll call, please.
Commissioner Manukian?
Yes.
Commissioner Gazarian?
I'm going to abstain.
Commissioner McCarley?
Yes.
Commissioner Devine?
Yes.
Chair Upkarian.
Yes. What's next?
Jurisdiction of the Civil Service Commission over investigations.
All right, Ms. Scarpetti.
Mr. Chair, members of the Commission, during your January 16, 2018 meeting, the Commission requested the City Attorney's Office prepare an opinion regarding the scope of the Commission's authority to make investigations. The Commission had requested a similar report in 2003 and again in 2008. Our close review indicated that there has not been any change in the law with regard to the Commission's authority, and as set forth in the City Charter, the Commission as a board or through a single commissioner has authority to conduct investigations concerning the enforcement and the effect of the rules that fall within its jurisdiction. The jurisdiction of the Commission is set forth in Article 24, Section 2 of the City Charter, which includes recruitment, examination, and selection for employment or promotion. The Commission is also responsible for hearing all disciplinary cases. Historically, the function of the investigation has been carried out by the Chief Examiner, initially as a volunteer member of the Commission, and later in 1937 as a paid staff person to the Commission. So the Commission used to be comprised of 3 individuals. Of the 3, one was designated as the Chief Examiner, and then in 1937 that became a paid person. From a professional and technical human resources perspective, the Chief Examiner is the Chief Administrator to this Commission, to this body, whose role it is to carry out the day-to-day duties of the Commission. He is a professional trained in all aspects of personnel matters. The Commission, in fact, has input into the hiring of the Chief Examiner and did so with Mr. Doyle's appointment. He is a professional trained in all aspects of personnel matters. It is for this reason that the duty of the investigations has been historically delegated to the Chief Examiner with the oversight and the reporting responsibility to the Commission. It's important to distinguish from the Commission's investigative authority the employee misconduct, malfeasance, or competence, which the Charter in Article 24, Section 9 squarely places with the appointing authority and requires that a copy of the order removing, suspending, or reducing the rank be filed with this Commission. So there's a distinction that's made in the Charter between the employee misconduct and those investigations, and that oversight being placed with the appointing authority, and then and the actual recruitment, examination, and selection of employees of employment. The separation of duties is required to preserve the constitutional due process afforded to employees, whereby the function of the investigating employee misconduct is separated from the due process hearing body. So the law makes a distinction between the body that does that conducts the actual investigation of misconduct and then allows for that employee to have a fair and impartial hearing before this body. So that's a quick summary of the written report that was provided to the commission. Both Mr. Doyle and I are available to answer any questions, both as it relates to the law or our practice.
Okay, any questions?
May the record reflect that I'm here.
May
I
the
don't think.
record reflect that Commissioner Gazarian has joined us almost 10 minutes ago.
I think I'll commence the conversation. I commend the Deputy City Attorney, our Senior Assistant City Attorney, for the well-crafted memorandum regarding the authorities vested in the Commission. I do note that she made reference to what I would call the separation of responsibilities between this Commission as a hearing body, for which it has been engaged on numerous occasions, and the area in which it has the right and perhaps under certain circumstances the duties to investigate the implementation and the interpretation of the rules and the enforcement of those civil service rules within the city employee community. There is, from my perspective, a hazy line as to the term enforcement of rules and regulations and the efficiency of the service. I think that there could be quite a conversation, really almost a jurisdictional conversation, if one of our members sought to pursue an investigation into an area that certainly relates to employment, but perhaps touches upon an issue of criticality, whether that is diversity or the examination process, again, all of which relate to what we do. At the present point in time, I see nothing on the horizon that suggests that there's any person or entity out there that wants to degrade or negate our ability as a commission to conduct investigations that encompass or track that particular provision that's noted in the charter, and that is the enforcement and the rules and efficiency of the service. Until we have a particular issue or a specific request upon the part of a commissioner, again, this is a very valuable memorandum. I am sure that we will refer to it at the point in time when one of my brother commissioners comes forth and makes a motion to investigate. At that particular point in time, this becomes critical. As I thought about it earlier, it's a very interesting legal discussion if this commission, upon approval of a majority of its members, commenced an investigation that might indeed touch upon sensitive subjects within the city, which this issue has some relationship to employer-employee relations. And then an entity, whether it's the city manager, and this is to cast no aspersions against our extraordinary city manager, but city manager or some authority, appointing authority, would come forth and say that we've exceeded our jurisdiction. It's an interesting legal question because I'm not so sure that there would be any entity that would preclude us from pursuing that investigation. The only body to which we adhere, besides the law, which is our all-encompassing obligation, is the city council. And perhaps at that particular period of time, the city council could move forward and suggest that we've exceeded our jurisdiction. But again, it's a very, very interesting memorandum. And hopefully we'll never be asked to look at this in great detail. But the potential exists, and I know it has been a subject of inquiry by several of my fellow commissioners. And again, I applaud you for the rigor that was found in this document.
Anyone else? Any questions? I have two quick questions. First of all, I just wanted to also mention that I felt that the report was extremely detailed, and I want to thank you for spending the time to really detail what we needed to actually have. So for that, I want to thank you. If there is a request by a commissioner to look at general exams to see if they're in any way discriminatory or not. Is that within the jurisdiction of the Civil Service Commission? As a general rule, to review exams to see if they're actually discriminatory, they're unfair, they're disparate treatment, that wouldn't be specific to a particular individual. It'd be just a general review. Based on what I read in here, my understanding is that that would be under the privy of the Civil Service Commission.
So, correct. Chair Abkarian, when you're looking at the fairness of the testing process, when you're looking at how a test was administered, those are all areas that that would fall within the commission's purview. And if you recall, through your chief examiner, investigations are conducted on a fairly regular basis. So if a matter is brought to his attention and he reviews it and determines that there was a process that took place during an exam that may have impacted its fairness, then it is within his purview. As I think I had an example in here from 2016 where he dismissed the exam and then reported to the commission the results of his investigation, and then with the commission's oversight re-administered that test. So that's the kind of thing where when you're looking at the overall fairness of the test or how it's administered, that would fall within the commission's purview.
And even if this chief examiner doesn't bring it to our attention, a majority of the commissioners could vote to review it.
Yes.
The other question I have for you was, the due process has to do with the employee's right to be able to have a process where it's not discriminatory. My question is, how about if the employee says, no, I want to come in front of the Civil Service Commission on this particular issue? Could they come in here and ask for an investigation based on what they feel is discriminatory, and then can we do an investigation at that point?
So,
because he's already waived technically his due process right by coming to us and saying, I understand I had a due process right of being investigated by the city manager. I don't want to do that. I want to go ahead and have the Civil Service Commission as a body investigate because I think there's discrimination. So I want to see, is that part of our privy to do that or not, if he waives his due process right?
Chair Perian, the employee cannot alter the process that's set forth in the charter. So, for example, if there's an allegation of misconduct on the part of the appointing authority, that appointing authority also has civil service rights. So if the employee says, I feel that for whatever reason there was misconduct on the part of my supervisor in administering my duties, I would like the Civil Service Commission to investigate this matter instead of having the appropriate channel, which would be either the city manager's office or that individual's supervisor. So it's not the employee who gets to waive that right, because there are other rights.
The process can't be waived.
Yeah, there are other rights that are triggered, and thereby it's not incumbent on a single employee to determine the fate of the others.
Mr. Chair? And that comment is, again, greatly appreciated, Ms. City Attorney, because I think that comment bleeds into the following discussion, and that's the one in which we address the authority to review complaints. And this is where we have that blurring. We have to be very conscious and avoid the blurring of lines between this body as a quasi-judicial body, a hearing body which determines the truth or lack thereof during the course of a hearing, and that which is something akin to an investigation or investigatory body. And I've always operated, when we're talking about a specific individual with a complaint, and that complaint is his or hers alone, then the executive or the administration, the management of the city, has that responsibility to conduct those investigations. Now, the difficulty we have, and it came up once or twice, is because this city lacks something akin to an inspector general or a third neutral review party, because there are many instances in which an employee might have a complaint, wants to address that complaint, but does not want to address it within his or her particular hierarchy or chain of command. What they want to do is to find a neutral individual with whom they can come forth, say, this is what happened to me on the job. There's this cocoon of confidentiality that surrounds the reporting, and then that investigator, there's a term we used to use in the service called an inspector general. It's the same sort of inspector general that's used in the police department, not this one, but LAPD, and as well as Los Angeles Sheriff's Department. And that investigator, IG, Inspector General, then would conduct the investigation. And if the findings are such that suggest that there's misconduct, then that Inspector General reports to the appropriate commission and reports to the management of the governmental organization. We don't have that, and that's the reason we get instances in which members, either members of the public or our employees of this great city, come forth, tap us on the shoulder and say there's something wrong here, because there's something, this particular position does not exist, and frankly, over the long term, it's certainly not our province to suggest what the council should or should not do, is that the creation of something akin to an inspector general or a third-party neutral who can hear the complaints is something I think is needed.
Commissioner Kazarian, then
Thank you. First of all, thank you, Ms. Varbethian, for the memorandum. I found it very informative. In fact, I found it historically very telling that as far back in 2008, the city attorney had provided this commission, or members of this commission at the time, with a better understanding. Specifically, I'm referring to the phrase efficiency of the service. And before I go into some of my comments, my fellow commissioner is referring to Inspector General. I always thought that we were the Inspector Generals. I really did think that, and maybe I've been mistaken this whole time, because unless we're going to change an entire system, and I don't think that we have that authority, at least I don't think we have that authority. In reading this June 13, 2018 interdepartmental communication, on page 19, it cites on the first line, in the 2008 memorandum, the city attorney's office concluded, and I assume it has not been contradicted, disputed, or found to be improperly reached conclusion, that the Commission's authority to make investigations concerning the efficiency of the service pertains to, seems to be just about everything we do here: recruitment, examination, selection for employment or promotion, and the hearing of disciplinary cases. I'm not sure what it is that we're trying to be enlightened about or bring further enlightenment to the existing processes. I am heeding further writing of this memorandum on the second half of page 19, where it reads, thus the charter vests only the Commission with the authority to hear appeals of discipline which may arise from misconduct or incompetence. And then it goes into the constitutional due process matters that Chair Abkarian, I believe, may have referenced in inquiring about it from Ms. Varbethian. And I vividly recall the 2015, late 2015 incident where our chief examiner, having come into contact with information or evidence to suggest that the police captain's examination was not done according to what should have been done, certain fairness standards, if you will, brought it to our attention. The test was nullified. A new test was then instituted. And since that new test, I too have heard on individual basis complaint or complaints that, oh, well, the second test was not fair either. Now, why do I bring this up again? Because I recall very well a fine lady standing right here in front of us and saying, I want you to investigate. And I remember myself being perhaps a bit aggressive at the time, saying, investigate what? Somebody has admitted a wrongdoing, so what am I supposed to investigate if they've admitted the wrongdoing? This word investigate, this power to investigate, needs to be understood, at least by me, because I am now at a place where I am wondering, have I misunderstood the meaning of that all this time? Because in reading this memorandum, I am encouraged that no, I have not misunderstood. I don't think I have any additional powers to investigate other than that which I thought I had, which are limited to the recruitment, examination, selection for employment or promotion, and the hearing of disciplinary cases. And in the hearing of the disciplinary cases, I am mindful of the fact that we have a subpoena power, we have the ability to order the parties to present us with additional information, documents. I've had the honor to take part in some of these disciplinary proceedings in the past, in closed sessions. So when I look at page 20, the first full paragraph, it says the process of reviewing and investigating that particular exam, it was referring to the captain's exam of 2015 and then early 2016 redoing of that exam, fell within the commission's purview. The commission did not then have authority to investigate the actions of the chief, and I believe that means chief of police, then, or any other employee in the context of any possible misconduct. That is why I was at the time saying, investigate what? Because I was thinking, I don't have the power to investigate a police chief. That seems to me to fall in the purview of city management office and into the domain of city council. That was my understanding. That duty, actually the memo says that duty would have fallen squarely within the authority of the city manager with all due privacy protections required by law to the employee being investigated. Now, if any one person in that process, feeling, believing, perceiving, or being aggrieved by an action of a superior, does have the ability to file a grievance, go through the process, reach a Skelly officer stage, and then, if not satisfied, come to this body. And this body, again, I end as I began. I believe it to be, my dear Commissioner and Commissioners, I believe it to be the Inspector General body. Because aren't we at the end the unbiased 5 individuals who, in goodwill and in good faith, listen to the evidence in those hearings that we've taken part in over the years and render an opinion, and then collectively we reach a consensus, or we agree to disagree and we reach a majority opinion? So I don't know what more do we need to know about our rights and duties and abilities to investigate any more than it has been made clear to me. It has been clear to me, so maybe I'm missing something. I know this was an exercise that you, Chair Abkarian, had put a lot of heart and soul in it, so there must be something that is driving it that perhaps makes makes you, makes me maybe, that I am not aware of, not really realizing the true calling of my commitment, my volunteerism in this seat, on this dais in this city. So if I'm missing something, I want to be made aware today, because I want to move on knowing that what I've been doing and what I may continue to be doing is what I know to be doing.
If you know everything you need to do, you might actually resign from the board, so we won't tell you.
Okay.
Commissioner Menuchyan.
Let me share with you my understanding. I'm not an attorney, but at least my understanding of what our role and why we can't be the Inspector General. This is just my opinion. We are the same body that ultimately hears the case and makes a decision accordingly. So for us to be both the investigator and to be the body, again, I'm not an attorney, but I think there's some kind of a conflict there. And it's always been and not to say that we should, I guess what I'm trying to say is, the way we've at least gone about doing it, the body that hears the complaint or hears the issue at hand, if we come across anything throughout that process that concerns us or something that requires investigation, it's always been, at least our approach, that we've notified Matt or the city attorney's office, and they have looked into it, they've done their investigation. But I think this is where that area of investigating, going to the point of for us to investigate an issue and yet also be the hearing body, because we don't know where that investigation goes. If there's an issue that, for example, that someone complains about, something that has happened to them, and we are the ones that start investigating, well, it turns out at the end, if that person has to come in front of us, again, but I'm a believer that this commission was formed for the intent of getting to the bottom of things. Now, that's where I think we run into this issue of how do we look into something and also be fair person to sit there and be best. Just my opinion, that's all.
Go ahead.
Well, I've been hearing all these comments, and I think they're all good. I've heard this, Albert and I have been around for quite a while on this commission, and this has come up several times. And the question that formed in my mind as I was listening to everyone is, what's the problem we're trying to solve right now? What are we doing here? Why are we having this discussion for me, it's been the third time now over the years. And I'm trying to think of what problem or what brought this up that caused us to spend the last 20 or 30 minutes talking about this. So that's what I need to know. Hi.
A couple of questions were asked. Mr. Kazarian said Albert was so passionate he brought this up and everything else. I needed to get this on the record because so many people either send emails, make phone calls, approach us thinking that we have the authority to actually go out there and start, hiring investigators and getting the police department involved and investigating some kind of discrimination against an employee. And I want to make it very clear that, and maybe I had the reverse idea of bringing this up, not because I wanted to say that I want to have the authority to do what we do, but I want the employees to understand that we are the Court of Appeals, in my opinion. We are the Court of Appeals. You go through, the district attorney files it, you go through the trial, you don't like what you hear, then you can appeal to us. We don't, appellate courts don't go and start investigating things that have nothing, that's not under their privy. So I want the employees to understand, by calling us, by talking to us, by trying to shame us into trying to investigate something having to do with employment, it doesn't automatically gives us the authority, no matter how much we want to have the authority, to go out there now and start knocking heads and do things. To answer your question, Mr. Devine, my purpose of bringing this up, doing my own investigation, because I was told that I'm incompetent commissioner by not being able to handle some of this discrimination and this improper and blah, 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 all these questions. And I wanted to tell people, you want to go to city council, you can. You want to come here in open public and say something, you can. You want to go to your processes and finish it and appeal it to us, we'll be more than happy to be fair. But we're not going to go out there independently and start investigating claims of discrimination, claims of improper examination. I don't believe that first, don't have the time to do that. I didn't sign up for it. And second, we are the appellate court. You want to go through the process, do it. Then if you don't believe that you've given a fair shake, then come to us. But don't call us to start investigations and then tell us that we don't know what we're doing because we're not bringing up a particular investigative request by an employee. And which also tailors into why I asked for the next one. As to, I think they're intertwined.
I'm glad you brought it up. I'm glad you brought it up.
So this way, then, now at least if there's an employee, they understand what our rights are, what we can and can't hear, so they don't approach us having to do with anything to do with the processes. We have a general authority to look over things to make sure they're fairly applied to everyone, but we don't have the authority to investigate individual actions against an individual party, unless if it's brought to us after they've already vetted the process within the city.
Mr. Chair.
Go ahead.
I have deep respect and appreciation for the comments of our chair and as well Commissioner Devine. I think the question for me, in a sense, it's a response to your observation, is this. If we have an employee whistleblower and that employee wants to bring forth what he or she believes is either misconduct in the promotion activity within his or her particular department, the question is, where does that employee go so that he or she can relay, can describe this particular complaint and do so without fear of retaliation? Now, I know we have a multiplicity of statutes on our books in the government code and civil code that is supposed to punish senior employees who engage in retaliation. But fundamentally, the question is, where does that employee go? And sometimes what has happened, for me, for instance, is that one or more employees has tapped me on the shoulder for the purpose of reporting what they believe is something wrong with the employment or promotion process or application opportunity, all that sort of stuff. So the question is, where do I refer it to? I concur with our chair that our response, and with Mr. Manoukian, that we are in fact a quasi-judicial body. We make decisions, we can't investigate and therefore have a hearing about the same people that we investigate. That would be a true blurring and an absolute abject conflict. But I need to know, as the most junior of the commissioners here, where the heck do I send that employee who has a legitimate complaint to the point of being a whistleblower?
The next report.
That's a great
Mr.
question.
Devine, make his comment and maybe you can.
That's a great question, and that's answered in the next report we're going to be considering. So as soon as we get to that.
I was going to I kind of merged them together because they're actually agendized, so we can kind of talk about it as well.
Sure.
And if we read that next item into the
Yeah,
record,
why don't we go ahead and
can
read the
also
next
discuss
item
that,
into
but
the
I think
record?
you've got a
Something.
specific comment
Yeah,
there.
hold on 1 second. Just go ahead and read the next item on the record.
Commission's authority to review complaints.
Okay, Commissioner Guzeri.
Thank you. First, I want to correct myself because when I was referring to it, we are the Inspector Generals. I was keyed off of something that Commissioner McCarley said. I think Commissioner McCarley, if I didn't hear you correctly, please correct me. I thought you were concerned, and I believe you are, that where does someone, and not just what you just said a moment ago, but even earlier in your remarks, where does someone go to get a neutral, unbiased, sympathetic ear to their perceived wrongdoing that they are being subjected to? And in that context is what I kept saying, that we are the Inspector General, meaning we are that neutral body. And the reason I said that is because, and this goes to your last inquiry, I remember getting a letter, when I was chair of this commission, I remember getting a letter from an attorney who was representing a member of the city. I will not name what department. And that attorney was bringing to my attention as chair of the commission a particular issue about certain payments, 5% more, 5% less, etc. I asked for a special hearing to be set. Now, I went through some issues with that. I believe, they see my chief examiner is smiling. And I recall having issues about posting a notice to have that special hearing. And Commissioner McCarley, I posted that notice myself, and we had that special meeting. So that person, through counsel, ended up coming before this commission. Now, I don't know if that was part and parcel of another ongoing proceeding. In fact, I dare say it was not, because there had been a previous proceeding that I did not take part in as a hearing officer. This was separate and apart. So my understanding is that nothing prohibits, if somebody, for example, a whistleblower or someone who feels that they are disgruntled, and I'm going to look for Ms. Varbetian to educate us on this to the extent that there is material on this issue. If somebody then reaches to the commission, I at the time reached out to fellow commissioners, and I chose to have a special meeting, and I tried to hear that matter. I believe I continued it because the appointing authority needed a continuance, but then the matter resolved itself. But I wanted to do everything I could for this body to be available, and I remember it very well. It was a Monday night that we had the special meeting.
We all remember it.
Okay. So Ms. Varbetian, is that something that addresses the hypothetical of Commissioner McCarley, or no?
I can go into the next report if you're ready for
Okay.
that.
Before we go, I just want to make sure that we cleared all the questions having to do with that particular report.
And we
Any
can
other
come back
questions?
if you.
We can
because
come back to it
yeah.
if you want to. So, okay, why don't we do this? Why don't we already read the next item into the record, so Ms. Ward-Pedian, why don't you go ahead?
So consistent with the discussion that you're having in understanding the frustration that you feel when you have individual employees or members of the public that approach you with your powers to do investigations, it is important to understand that there are a great deal of limitations. Some that are self-imposed by the employee because of their request for anonymity, and a greater one, really, by state law, the Brown Act, that controls all legislative bodies, including this commission, that prohibits you from having separate, confidential meetings by a majority of the commission. So that absolutely is not possible. You cannot meet as a body outside of a publicly televised meeting. So the request was, well, what do I do as a commissioner if I receive this type of a request? And albeit the report does say that you'd have to weigh the alternatives, you'd have to make some decisions as to what is the best course of action for each type of incident. But we've provided you with, I think, 6 different alternatives. The first one is to encourage the employee to attend the commission meeting and speak here to the commission as a body.
But let me just stop you there. I'm sorry, I don't mean to cut you off, but I want to, when we're going through this one by one, I want to understand. Wouldn't that, if that employee comes in and starts talking about discrimination, all the rest of the stuff, isn't that what you were talking about somebody now bringing up a discrimination where the appointing authority hasn't had a chance to really do anything else, and now we are hearing one side. If we encourage them to come here, now we're hearing one side without the other side having a opportunity, and that individual then could kind of murky our brain to a point, well, hopefully won't, but it could, before the appointing authority had a chance to do anything.
So, Chair,
and the appointing authority has the burden of proof, not the individual.
Chair Perrin, you raise a good point. I should have premised the discussion by saying that the complaints have to be within the subject matter jurisdiction of the commission. So if you remember from the prior report, the complaints have to relate to the recruitment, the examination, and the selection for employment. If they're alleging any other type of misconduct, this commission would not have the ability to direct its chief examiner to conduct any type of an investigation. So it does need to fall within your jurisdiction.
I just want to, this is very important to me. I spend my own money trying to understand this because of all this import of all these questions. There's not a commissioner sitting on this bench or commissioner that has been sitting here who has not had those phone calls, who has not had those discussions outside at a party somewhere, where they basically said, what are you guys doing? What's going on? I want to make this very, very clear. I mean, I appreciate all, and we'll go over the rest of the options. My understanding is that our job is to fairly hear a case that has been vetted by the city manager's office or by you. And based on that, make a decision as to the fairness of the decision in favor or against the employee, or against the exam, or against anything else. That's what my understanding is. I don't want to ask an employee to come, I mean, anyone could come on public oral communication and say whatever they want. That's their constitutional right, that's the First Amendment right that they have. But I don't want to encourage them to come and talk about something that then we have to hear and judge on.
So it goes back to the type of complaint that it is, and that you have to assess it when it's made. So if the employee says to you privately, my supervisor keeps making racial slurs, that is outside the scope of your jurisdiction. That is something where you wouldn't encourage the employee to come up.
My recommendation is, wouldn't we tell that employee, we'll be more than happy to review anything you have after you vetted the process with the processes within the city. If that's not satisfactory, then our body will be more than happy to fairly hear your appeal, which is what we are.
That is one of the
We're the
later
appellate
proposals.
court, so to speak. Again, I want to say it. We are not a body that investigates. We're not a body that goes out there and gets the police to do, or whoever it is, city attorney's office.
So in that example, for example, the one that you gave with an employee complaining about something that does not relate to
The sergeant's exam wasn't right. The management exam was discriminatory. I mean, these are general stuff because they're saying the exam was, but if you investigate it, you might end up on the left or you might end up on the right.
Sure.
And again, I want to just let everyone know, and I just want to see if I have your support in here saying it, and please, anyone else chime in. I mean, I don't want to take this. I want the employees to understand that I would love to help anyone, and I've always said, I want to do what's fair, always. I don't care the consequences. But we don't have the jurisdiction to come and sit here and start investigating exams. Unless if it has to do with a more of a general purpose of making sure that there's not a discriminatory exam written. But in reference to anything else, we want to be the last resort, not the first resort, which is what some employees believe we should be. We can't be the first resort. We have to be the final resort after they've gone through the process. I don't know what the answer is. If somebody believes that the entire city is against them, I don't have the answer as where they need to go. I don't. And I don't know if you have an answer, you're more than welcome to give it to us. But where does that person who believes that the entire city is against them go to feel that they've gotten a fair process?
Well, I thought I read, I thought I read, Ms. Barbetian, in the materials, not today, but yesterday, the day before, in some time that I put aside, the ability to form ad hoc committees of this commission made up of 2, but not 3 commissioners who then can meet with such dissatisfied or complaining employees, hear their concerns, What I don't recall is what do they do with that afterwards? Do they then bring it to the chief examiner or whatnot?
So there's quite a few items that's discussed. That is one of the alternatives that was proposed. In the example, in that very first example, where our office recommends that you can encourage an employee to come to this meeting, to this body. So, for example, if an employee says, complains to you personally that that my supervisor consistently makes racial slurs. That is actually misconduct. It's illegal, and that is something that would come to this commission after an investigation is done at a different level by way of potentially an appeal to the commission.
So our answer to that particular person would be, please go through the process of the city, and if the process, at the end of the process, you're unhappy, the body will treat you fairly and will hear your complaint.
But
That's
yes,
correct. If I could interject, Mr. Chair, if it's racial slurs, you should really direct that person to contact any number of city officials who are really stated within our city policies that they can talk to about something like that. If they're not comfortable going to their supervisor, they can go to the manager level. If they're not comfortable going there, they can go to the Human Resources Department. If they're not comfortable going there, they can go to the Internal Audit Department. If they're not comfortable there, they can go to the city manager. They can go any number of places.
Directly to the city attorney's office.
City attorney as well. We just, I don't want to expand upon that example, but we do harassment training for all employees every other year, and with that training, it's 4 hours. Every employee, not just our supervisors. We give them the policy, reissue it, and it has a very clear listing of all the individuals that they're authorized to contact. And if they can't, find it, they're concerned about any number of those people, then I guess they can come back to you as an individual commissioner and say, hey, I'm not comfortable with that. And if that's the case, then I would expect one of you to contact me where I could do something about it or pursue it. But something along those lines, there's a mechanism internally for addressing them, and we would investigate it, and at the end, if we end up disciplining someone, that may find its way back to the commission in the form of a hearing. With regard to matters directly within the purview of this commission, as outlined in Ms. Varpetian's 2 reports, I would say it would be perfectly appropriate for any individual to speak to you individually or to come here and speak before the commission about their specific concerns relative to exams, testing, examination, and matters directly within the purview.
I want to just make one mention. There's no one that's told by the city manager's office or by the human resources that, oh, I'm sorry, this item cannot be appealed to the Civil Service Commission.
I didn't understand that. I'm sorry.
It depends on what the matter
If
is.
they go through the process and they're unhappy with the process and they would like to appeal that, whatever the decision is, are there exceptions where they cannot bring items in front of Civil Service Commission?
so it had.
M-step. I don't know, somebody wasn't given M-step, they're unhappy. I didn't even know what M-step was until somebody explained it to me. M-step is I guess, an increase in
That's salary related.
merit
I see.
step.
And they say, well, no, you're not entitled to get the M-step, and they say, well, we don't agree with the decision of our supervisor, and the city manager doesn't agree. Can they bring that up to us in the Civil Service Commission as a fair body to try to see if they should get the M-step or not?
I wouldn't think so. That's more of a performance issue. If the individual has not, if they had to go through a competitive process and they're alleging that the testing process resulted in such that they did not receive a benefit, and their allegation is that the testing process was unfair, it's that process that they can bring forward.
So
But
it
if an
could come to
individual,
us.
yes, but if the individual, through general performance, could have been entitled to an increase in pay, and the supervisor felt that they were undeserving for whatever reason, that is more of a performance issue.
How about if they say supervisor just discriminates against me all the time, they hates me all the time. So I appealed it to the city manager, but the city manager said they're buddies, they go and drink together, so I'm not saying that that's happening.
It's a
I'm just giving you an
performance issue,
example.
and it would
Question, where did they go? That is a good question.
I want to say, now where did that person go? Now they said, now they've gone through the process, they vetted the process, and the city manager said, no.
They can
you can't.
avail themselves of private counsel and potentially take up the city, sue the city, if they really feel like, I mean, it's not a one-stop shop. You can't always come to the commission. If you're not performing properly and your supervisor does not reward you with additional pay, and you're still unsatisfied, and you try to go through the process, and you're still unsuccessful after knocking on multiple doors, then, and you feel strongly about your attributes and the contribution you make to the city, and it's not rewarded properly, then you can seek employment elsewhere, or you can hire an attorney and pursue it that way.
Well, I think that that's the one concern that we have. I was going to suggest the same.
Yeah, that's a
Certainly,
problem for me.
that's part of our professional expertise, but it concerns me that an employee would be forced to secure private counsel, pursue a claim either with the EEOC or FEHA, and then subsequently either the state courts or the federal courts to get redress with respect to some employment issue. And I like the hypothetical that Commissioner Abkarian brought forth, and that is an employee, rightly or wrongly, has this observation, a perception that his or her supervisor is discriminating against all people of a certain nationality, ethnicity, or they all have the name Mac. But that's the potential. So again, it's almost full circle. It says, where does that employee go where it's not the immediate denial of an anticipated benefit, such as a promotion or a step grade, a performance step grade action, but is indeed an observation that there's a flaw within the particular department in which he or she works, a flaw to the extent that he or she does not believe they get a fair shake because they're never promoted, and anybody that looks like them or has the same sort of last name is not promoted. And that's the type of tap on the shoulders that we get.
Well, I think Mr. Doyle described for you earlier the different avenues that are available to employees. And if all of those fail and that person still feels that they don't have fairness in the city, then that's when they would avail themselves of private counsel.
And I absolutely appreciate that that is the response. If you do the deductive reasoning, which you've so adroitly and professionally brought forward to us, that is what would happen. It just goes back to my same theme. I'm sort of publishing it for those who would listen or watch this TV program, is I think that there's a necessity for some sort of quasi-neutral individual within the city, whether it's an extension of Matt Doyle and a chief examiner who has this ability to maintain confidentiality with respect to complaints of an employee. Again, the reference I have, the reference that I'm familiar with, and of course, Commissioner Gazarian brought this up, so did I, is this sort of inspector general concept, not alien, not foreign. It's just as somebody they can talk to who then has investigation authorities and then can bring the results of that investigation firstly to the city manager and then later to the commission.
Hold on, yeah, Mr. Minigan.
Just, personally, I have a big problem by telling somebody, you go get an attorney and sue. Because
Yeah.
at that point, I don't think your point of, you cannot, I mean, we can talk about this further and maybe come up with a suggestion, because of course, anyone has the right to get legal counsel, but if that happens, I think we failed. That, to me, that's, because that means there was not a system or a way that we could have at least addressed it. That's all. I mean, just, but I hear.
There are a number of other alternatives in the report. If you'd like to hear them, that was just the first one.
Yeah, let me have Mr. Commissioner Devine say his piece. And
I was just going to suggest that we listen to the rest of Lucy's report and find out the 5 other items before we reinvent the wheel here.
I think the issue was we all
You
read
always
it.
have the good advice. You should go first.
Actually,
That's a good idea.
I'm going to leave in 15, 20 minutes. I have my mother in between hospitals.
I think we'll be
Do
done
you,
by then.
Do you want to make a comment on this before you leave?
No, I'm good right now.
Okay, So just go ahead, please.
The next alternative for consideration is that after hearing an employee's complaint and encouraging the employee to come, and for whatever reason, if the employee chooses not to, the commissioner himself could bring the matter up during a commission meeting and provide the commission an opportunity to consider the matter and discuss it. The next one, and this probably fits best with the discussion that we were having a moment ago, is with regard to the employee hotline. City of Glendale has contracted with an independent reporting service to relay reported suspected incidences of fraud, waste, abuse, and inappropriate employee behavior. The independent employee hotline is not situated within the City of Glendale. It's an 800 number. And when someone calls, they're not speaking with a City of Glendale employee. It's a completely different service. They then take information down. They do not record information. They do not share the voice of the person. It could be completely anonymous. And then that information is gathered and then directed to the appropriate city official. And that could mean, as Mr. Doyle outlined, the city auditor, the city attorney, the human resources. And I do want to provide that phone number just in case someone's listening. It's 1-844-703-1791. The next alternative is that the commissioner may contact the chief examiner or the city attorney and have a discussion with one of them and review the alternatives available and then relay that message back to the employee. There is an option in here to create an ad hoc committee of the commission. This is something Commissioner Kazarian alluded to earlier. Please know, because of the Brown Act, you are limited to discussing any matter within the purview of the commission with only one other commissioner. So while you have the ability to do that, formalizing it in the form of an ad hoc committee who specifically takes on the role of reviewing it and discussing it so that it does not feel like there's just the one commissioner who's had contact with that one employee, but there are two commissioners who may potentially have that discussion, assess the value of the comments that are made, consider the different alternatives available, and then take on the role of either bringing it back to the commission for review, directing if it's within your purview, directing the chief examiner to conduct an investigation. And then the very last.
Again, just a question. Neither of those two commissioners could not be one of the three hearing officers.
If the commission has taken on a responsibility such that they have gathered enough information where they feel they can no longer be impartial, then that would be true.
I mean, they can't be if they're ad hoc and they have all the information, and now you're going into a hearing, and those two people have already heard the case, so to speak, and now they're going to be sitting as one of the 2 out of 3 in a hearing.
They've only heard one side of the story with one employee presenting. So if the commissioner feels like, I mean, you take yourself, as you talked about the being in the Court of Appeals, certain public cases, judges aren't immune from hearing things on TV or on social media. So you have to weigh that with the volume of information received and the credibility of the information received, and understand that it's only one side of the story. But if there is enough to the story, then you may want to refer it for further review, and then really feel like you've taken on some responsibility in providing a response to the employee.
And then the last one.
The last one was not every complaint that comes to you is credible, and so perhaps sometimes saying thanks for lodging that with us, but it stops here. I don't intend to do anything more.
I just have one comment. My understanding was that I don't want to get into an investigation. I don't want people to come to me if they're asking us to investigate. But once the investigation is done, once they've gone through the process, once they've vetted everything, and they're at the end of the line and there's nowhere else to go, for me to tell them to go and get an attorney is not what I want to tell them. What my hope is that every appeal and a request for appeal will come to us. And at that point, the commission based on what the city attorney's office will tell us, if we have jurisdiction or not on that particular issue, we'll then make a decision, could we hear that appeal or not? Instead of just having somebody outside of this commission make a decision that the commission does not hear these items without giving us the opportunity to at least say, we won't hear it because the city attorney will tell us no, because this doesn't go under your privy or something, and then we'll make a decision, right, that's not an appeal that we should hear. But to just tell people, have the city manager or the chief examiner or anyone make a decision that no, this is not appealable and this is appealable, and make a decision on our behalf. I have a problem with that, especially if they've already gone through the process, vetted the process, and they're at the end of the line and say, well, I want to appeal this to the Civil Service Commission. It should come in front of us. We should be given an opportunity at the end, not at the beginning, not during the investigation. At the end, we should be given an opportunity with the city attorney's recommendations to make a decision. Is that an item that we can or we cannot hear? Not the city attorney, not the chief examiner.
Mr. Chair, if I could say, that's how the system works. I mean, there's a
But
whole...
I just asked the question. This is why, I just asked the question. You said, and the city attorney said, on that particular question, then they have a right to go to hire an attorney and go and seek legal action.
I'm
On
sorry.
that particular situation, I wanted to have an opportunity for them to come to us and for us to say, I'm sorry, there's nothing we can do, or no, we will hear this appeal.
I'm sorry, then I misunderstood your,
Okay, sorry.
your example, because I understood your example to be that an employee is unhappy because they didn't receive an increase in pay.
Whatever the decision is, they said that I didn't get my M-step because there was a problem.
Right.
They go through the city manager's office, they go do a hearing, they finish the hearing, and they're not happy with that decision. They say, we want to appeal this decision to the commission. That appeal should come to us with the city attorney having input, saying, I'm sorry, guys, you guys can't hear this because of A, B, and C. Then we will say, based on this, we can't hear it, or we can say, no, we disagree, I think we can hear this because of A, B, D, some other action.
Right.
So we should be the final decision maker instead of just sending them out saying, get an attorney and there's nothing we can
No,
do.
I don't want to speak for Mr. Doyle, but when a communication comes to Mr. Doyle that is directed to the commission, then he forwards it to the commission, at least to the chair, and then there's a
When we
discussion.
make a decision, could we hear an appeal or not hear an appeal on a particular employee, not someone outside of this commission?
Correct. So if an appeal
I have
comes,
no issues with that.
if the appeal comes to the commission, and it's typically directed through your chief examiner, he then forwards that information to
That's
you.
exactly, somebody goes to Mr. Dole and said, I've gone through the process, there was a decision by the city manager, by whoever it is, this is just a hypothetical, and say, I would like to have this appeal to the Civil Service Commission. Mr. Dole doesn't say, I'm sorry, this is not appealable to the Civil Service Commission.
Mr.
He will
Doyle,
bring it to us, and then we will make a decision if it's appealable or not with the city attorney's input. Yes or no?
not exactly in that context.
If it is within the context or the purview of the commission, absolutely. If it's something that is so far outside the commission's authority, are you asking for
No.
something like if someone is not satisfied with the decision of the city manager, that they then, on a commission that isn't, very obviously within the commission's authority, that they have the ability to appeal the city manager's determination to the commission? Because
No.
that's not...
Well, my recommendation at that point is that if they're unhappy with the city manager's decision based on their salary, based on the exam, based on stuff that the commission has preview on, we should be the final decision maker, yes or no. For example, M-step wasn't given to someone, they're unhappy, and they go through the process, and the city manager says, no, you shouldn't get an M-step. That, I believe, is part of our...
I think that's what you're saying, that if it's under our purview,
If it is,
if,
yes.
if the complaint is, I don't agree with the city manager for giving me a white color car to use for that,
Correct.
I
No,
would say, hey buddy,
100%.
stick to the white color.
100%.
I just want to make one point as well. When you say you want everything to come to you, there are many occasions where at the administrative level I am able, or my staff, were able to resolve certain matters directly within
Matt,
the
this is
commission's
what's not,
purview
I'm talking about...
before it gets to you. So
I never asked for that to come to us, ever. I don't want anything to do it. I want to make this very clear to the employees, to everyone. I don't want to be personally, and I don't want to speak on behalf of my colleagues here. I don't want to be on the front lines investigating anything. That's not my job. And so when I say at the end of the line, I'm saying that they've come to you, they've gone to the city manager, they've gone through the process, and now they're not happy with your decision. What happens then?
It would come to you. If they desire to continue that
That's
to
it.
you.
If they
to-
desire, then they
To the
can-
commission, and it's something within the commission's purview, then they would have every right to come to you.
Done. Done.
All right.
And my recommendation would be, the reason I didn't want to go through all of them, because I don't believe that we should do any of these, talking about having an ad hoc committee doing everything else.
I'm not saying we should, I'm just referring
No, no, I
to
know.
some of the options
Lucy
that
just
I
laid
read.
out options.
great
We don't-
memorandum.
Yeah.
We don't have to
And,
take any of them.
Whoever comes to me, I just say, go see Albert.
okay,
And I don't
Yeah,
think
right.
that we even have, Mr. Chair, even an
is-
actionable
is-
item. We have a report.
Is this an item that's got to be voted on?
No, I don't think so at all. This was a report that we sought.
Take your phone, take your phone. Mais bon, peut-être mieux, Zangi. Good job. Bye.
okay, we're done
On that item?
on that item?
We have
Okay,
9.
anyone else? Okay, what's next?
Review of potential civil service rules and regulations amendment regarding repeal of certification.
Mr. Guzarian, I'm going to go ahead and postpone this item until the next meeting, because I think you should be here for this item. Thank you. Item number 9 will be postponed to the next meeting, and we'll discuss this in the next meeting. What's next?
Reports?
Mr. Chair, members of the commission, the only item remaining are reports and information. We have the monthly past due performance evaluation report. And it has mostly no past due notices and a handful of first notices.
And 1/3 notice.
We're
You know what, city clerk's office should have been here tonight. Artie's a friend of mine, a very close friend of mine, and I would hate to do this for him, but he was here last time, he said he will get it done. Mr. Kazakian should have been here tonight. This is a complete disrespect to the Civil Service Commission, this is a complete disrespect to what we've put together. Artie's a good friend of mine, but if we actually make an exception for friends, then we make an exception for everyone. This is third notice, not second notice, and this was here last time as well.
It's the same individual.
It's the same individual, it was here last time, it wasn't dealt with, and I personally take offense that someone that should be a head of a department completely ignores the Civil Service Commission and just doesn't even show up when they knew that they had a third notice. Was notice given to them that this was third notice?
Yes.
I have nothing else to say. If we're wasting our time, we should just basically just trash this report, never ask for it again, because if it doesn't mean anything, what the Civil Service Commission asks for is someone to come and give an explanation, a 2-minute and 1-minute explanation. And if they really don't care what we say, why do we even have this report? Can we ask for this report not to be given to us from now on? Because it seems like it really matters none.
I would
think one
object to that.
person's-
I see value in the
Yeah,
report.
I think we should have the report.
But I think you have a valued comment, and we could exercise the subpoena power that we have.
I don't want to.
Well, the other thing, we have to look at, Mr. Kazakian's an elected official. And that's different than a department head, so I'm not sure. I'm going to ask our city attorney what jurisdiction the commission would have in requiring an elected official to come and talk about that.
Certainly, you can subpoena them, but Mr. Kasakian does adhere to the other rules and procedures that are required. He, in addition to being an elected official, he is also a department head. So part of his duties are to steer a department and be a department director, and the employees that work for him are not part of his elected staff. So they too have civil service protections, and part of what this commission has said is that part of the protections of civil service is to advise them of their performance in a timely fashion. So he couldn't ignore civil service rules because he's an elected official.
In answer to your question about abandoning this procedure or process, I would not be for that. I think this is done for the employees, and I think it's a service to the employees, and a very important one, and I would...
That's the reason we put it in here. We don't do this for us. We don't care about bringing somebody in front of us. We're doing this because when we actually do civil service hearings, if the performance evaluations are not done on a timely basis, then that completely throws off the entire process, because we review those and the employee said, if I had a disciplinary action, how come for 90 days no one said anything to me? That's the reason we need this,
So I
not
would
because
suggest
of
that we
anything
just
else.
continue that one and ask that he be here next meeting.
Mr. Chair, if I want to concur with Commissioner Devine. As much as not doing this report would create a lighter workload for my staff, because this is a lot of work, tracking all these people, and I mean, it's a whole organization, 1,600 salaried employees. I do see the benefit in this report, and in my lifetime here, I've seen the late evaluations shrink tremendously since this report has been done. And even more so, if you recall, the third notice is when we originally were requiring the department head to show up. We've made it the second notice, and that's even helped it even more. So I would not recommend doing away with this, because it has done a great deal of good.
Let's see
And it
what
really
happens.
does. And I wouldn't allow one department head to affect that decision. You'll notice you've not seen few other executives here having to address this over the
Chair.
years.
Might I suggest that we, on your signature, with the assistance of the chief examiner, address a letter to the city clerk advising him and requesting his attendance at our next meeting, unless he will have satisfied his obligations to this board by signing that performance evaluation. And then we'll have it on record, written document.
So by next meeting, he should have the performance evaluation complete.
Or he appears. It's sort of an order to show cause.
Let's leave it as is instead of addressing a letter. I would like to see what happens next time instead of pushing it one step further.
Okay.
I love what you're saying, but I'm just assuming that something happened. It's not the kind of person he is, and that's why I'm very surprised. So we'll just go ahead and note it for next meeting, and if next meeting he's not here and he still hasn't third notice, then
Well,
we have.
let me get clarity on this. If he turns this in prior to the next meeting, do you want his presence, or do you only want his presence
If he feels that he needs to come to the Civil Service Commission to apologize to the Civil Service Commission for not being here this week, he can. But if he turns in his employee evaluations, then unless if he wants to come and apologize to the Civil Service Commission, I would say under the rules, no.
And I believe that's the chair's prerogative based upon my understanding of the internal rules of this commission. Okay.
Okay, what's next?
Civil Service Commission, staff comments.
Any comments? None?
Mr. Chair,
Yes, go ahead. I'm
can I want to get clarity on whether we will have a quorum next month? It's
I was
July.
actually going to talk about that.
July the 11th is the date. I'm pretty sure Mr. Manukian will not be.
So based on Mr. Manukian's recommendation, the entire meeting will move to Lake Tahoe at his cabin. And he's paying for everyone to go there, and we're gonna have a great time. I had a recommendation as well to maybe basically skip the July meeting, if it's okay with everyone.
For me, my comment is I think that there's an importance to having a meeting monthly, whether we can move it and maneuver it to a date in which we know that the majority of us to make a quorum will be present. That makes me feel more comfortable and allows me to believe in my heart of hearts that I'm satisfying my obligations to the council.
I just think that the staff also has, it's very difficult to get, I mean, we can agree, and then all of a sudden the staff goes on vacation in July.
I actually am not going to be able to make this meeting, but I have
Got
people.
a worthy deputy.
Why don't we do this? Why don't we take it,
always call a special meeting,
if we need to. Yeah, if we need to have it. If you feel that there's an item that really requires our attention, let's wait until, let's say, 30th of the month. And if by then there's an item that really requires us to get together, then I think we should have the meeting unless if everyone is. But if by that date we feel that there really isn't anything on the agenda, then I guess we can cancel with Mr. McCarthy's approval.
With my objection, because there are multiple investigations that we now have to pursue based upon this grant of jurisdiction.
Okay.
Well, will the remainder of the commissioners be available on July the 11th as of today?
I'm not sure.
And we don't know
I don't know what,
Mr.
Mr.
Kazarian.
Kazarian's,
Okay.
schedule is. That's why I said let's.
I'll have Mr. Petrosian poll the members on June 30th and by email, if that's okay, without violating the Brown Act, to see what the availability would be for July the 11th. And we may have something urgent that...
Yeah, by June 30th, why don't we do that, on June 30th, and then let us know if there's anything of pressing matter that we would need to deal. If there isn't anything, then I think the decisions might come easier.
Okay.
Any motion to move?
move to adjourn?
Second. Boy,